The United States Patent System, a Substantive Analysis. The Innovation Attorney, April 2026. Executive Summary. The United States Patent System is the primary legal mechanism by which inventors secure exclusive rights to their inventions for a defined period, enabling the commercialization of technology and the creation of markets around proprietary assets, governed by Title 35 of the United States Code. The system grants three categories of patents: utility patents covering processes, machines, manufactures, and compositions of matter; design patents covering ornamental appearance; and plant patents covering asexually reproduced plant varieties. Approximately 350,000 utility patents are granted each year by the United States Patent and Trademark Office, and the total active patent portfolio in the United States represents trillions of dollars in asset value. The system rests on a constitutional bargain. Article 1, Section 8. Clause 8 of the Constitution grants Congress the power to promote the progress of science and the useful arts by securing for limited times to inventors the exclusive right to their discoveries. In exchange for public disclosure of how an invention works, the inventor receives a 20-year period of exclusivity from the filing date, after which the invention enters the public domain. That disclosure function is as important as the exclusivity function. The published patent record is one of the largest repositories of technical knowledge in the world. Several dimensions of the system demand attention from founders, investors, and technology executives. In 2026, subject matter eligibility under 35 U.S.C. Section 101 remains contested, particularly for software and artificial intelligence inventions, following the Supreme Court's 2014 decision in Alice Corporation v. CLS Bank International. The Patent Trial and Appeal Board continues to invalidate substantial percentages of challenged claims through inter-partes review proceedings. Patent prosecution timelines average 24 to 36 months, and the maintenance fee schedule creates a natural attrition mechanism by which patents that no longer justify their cost lapse. Opening markets to competitors. Understanding these mechanics is not optional for any enterprise whose competitive position depends on proprietary technology. Detailed findings. Patent types and their strategic significance. The utility patent is the workhorse of the American patent system. A utility patent covers how an invention works, the functional aspects of a process, machine, article of manufacture, or composition of matter, as specified in 35 U.S.C. Section 101. The term of protection is 20 years from the earliest effective filing date of a non-provisional application, subject to payment of maintenance fees at years 3.5, 7.5, and 11.5 after grant. Failure to pay any maintenance fee causes the patent to lapse, and the invention enters the public domain. The maintenance fee schedule is graduated. For a large entity, the fees run from $2,000 at the 3.5-year mark to $7,700 at the 11.5-year mark, with reduced rates for small entities and micro-entities. Design patents protect the ornamental appearance of an article of manufacture under 35 U.S.C. Section 171. The term is 15 years from the date of grant, and no maintenance fees are required. Design patents have become commercially significant in consumer electronics and fashion. Apple's design patents on the iPhone's graphical user interface elements have been litigated extensively, and the Federal Circuit's 2016 decision in Apple Incorporated v. Samsung Electronics Company established that design patent damages can extend to the entirety of an article's profits, not merely the patented component. Congress has since clarified this standard, but the episode illustrates the economic stakes of a single design patent. Plant patents cover distinct and new varieties of asexually reproduced plants under 35 U.S.C. Section 161, and they are the least frequently issued category, representing less than 1% of annual grants. Patentability requirements. An invention must satisfy 4 independent requirements to be patentable. It must be directed to patent-eligible subject matter under 35 U.S.C. Section 101. It must be novel under 35 U.S.C. Section 102. It must be non-obvious under 35 U.S.C. Section 103. And it must be adequately described and enabled under 35 U.S.C. Section 112. Subject matter eligibility is presently the most contested of the 4 requirements. The Supreme Court has identified 3 categories of exceptions to the otherwise broad statutory grant: laws of nature, natural phenomena, and abstract ideas. The court's 2012 decision in Mayo Collaborative Services versus Prometheus Laboratories and its 2014 decision in Alice Corporation v. CLS Bank International established a two-step analytical framework. Step 1 asks whether the claims are directed to one of the three exceptions. Step 2 asks whether the claims add something significantly more than the exception itself, an inventive concept that transforms the exception into a patent-eligible application. The USPTO issued updated guidance in July 2024, with particular attention to artificial intelligence inventions, clarifying that integration of an AI method into a practical application can satisfy the second step. The Federal Circuit's April 2025 decision in Substantive Analytics Incorporated v. Fox Corporation reaffirmed that merely applying machine learning to optimize a process does not, without more, constitute patent-eligible subject matter. The Supreme Court has declined to revisit the Alice framework despite dozens of certiorari petitions, leaving substantial uncertainty in the field. Novelty under Section 102 requires that every element of the claimed invention be absent from any single prior art reference. Any patent, printed publication, public use, sale, or other disclosure that predates the patent application by more than 1 year creates an absolute bar to patentability. The America Invents Act of 2011 converted the United States from a first-to-invent system to a first-inventor-to-file system, aligning the country more closely with international practice. A 1-year grace period protects inventors who have publicly disclosed their own invention before filing, but no corresponding grace period protects against third-party disclosures. Non-obviousness under Section 103 bars patents on inventions that would have been obvious to a person of ordinary skill in the art at the time of the invention. The Supreme Court's 1966 decision in Graham v. John Deere Company established the analytical framework, the scope and content of the prior art, the differences between the prior art and the claims, the level of ordinary skill in the pertinent art, and secondary considerations such as commercial success and long-felt need. The Court's 2007 decision in KSR International Company v. Teleflex Incorporated broadened the obviousness analysis by holding that a person of ordinary skill is not confined to following specific suggestions in the prior art, but rather can combine references using ordinary creativity. The patent prosecution process. Patent prosecution is the process of obtaining a patent through the USPTO. An applicant files a non-provisional application containing a specification, drawings, and claims. The specification must describe the invention in sufficient detail to enable a person of ordinary skill in the art to make and use it, and must set forth the best mode of practicing the invention known to the inventor at the time of filing. The claims define the metes and bounds of the patent right. Independent claims define the invention in their entirety, and dependent claims incorporate all limitations of the claim from which they depend and add further limitations. Following filing, the application is assigned to an art unit and an examiner with relevant technical expertise. A first office action, either a restriction requirement or a substantive examination, typically arrives 20 to 24 months after filing under standard examination. The USPTO's Track 1 program, which processes prioritized examination applications within approximately 12 months, accepted up to 20,000 requests in fiscal year 2025. The examiner issues an office action setting forth any rejections or objections, and the applicant has 3 months, extendable to 6 months with fees, to respond. After a final office action, the applicant may file a request for continued examination to reopen prosecution, appeal to the Patent Trial and Appeal Board, or both. Claim drafting is the most consequential act in the patent process. Claims that are too narrow may fail to cover commercially relevant embodiments of the invention. Claims that are too broad face heightened invalidity risk. Every amendment made to claims during prosecution creates prosecution history estoppel, which limits the patentee's ability to invoke the doctrine of equivalence to extend the claim scope beyond its literal terms. The Supreme Court's 2002 decision in Festo Corporation v. Shoketsu Kinzoku Kojo Jewelry Company established a presumption that any narrowing amendment creates estoppel as to the surrendered territory, with only limited exceptions. Skilled claim drafting therefore requires anticipating the scope of acceptable amendments before prosecution begins, a discipline that has significant bearing on the ultimate commercial value of the patent. The Patent Trial and Appeal Board and Post-Grant Proceedings. The America Invents Act created the Patent Trial and Appeal Board in 2012 and established two new post-grant proceedings: Inter partes review and post-grant review. Inter partes review, available for any patent and initiated within 1 year of service of a complaint alleging infringement, permits challenges based on patents and printed publications only, under the obviousness and anticipation standards of Sections 102 and 103. Post-grant review, available for the first 9 months after a patent grants, permits challenges based on any ground of invalidity. The statistics on inter partes review proceedings are striking. In fiscal year 2024, the PDAB received 1,288 petitions, of which 97% were inter partes review proceedings. Approximately 75 to 80% of challenged claims are canceled or significantly narrowed when a petition proceeds through a final written decision. The Federal Circuit affirms PTAB invalidity findings at a rate exceeding 90% on appeal. The technology distribution of petitions reflects the industries where patent disputes concentrate. 69% involve electrical and computer technology, 22% involve mechanical and business method inventions, and 6% involve biopharmaceuticals. For patent owners in the technology sector, the PDAB represents a constant validity risk that must be factored into any licensing strategy or litigation assessment. The PTAB also functions as an appellate tribunal for examiner rejections. An applicant who receives a final rejection and does not obtain allowance through a request for continued examination may appeal to the PTAB, which conducts de novo review of claim construction and reviews the examiner's factual findings for substantial evidence. A further appeal lies to the Federal Circuit or to the Eastern District of Virginia by way of a civil action. Patent infringement and enforcement. Patent infringement occurs when a party, without authorization, makes, uses, offers to sell, sells, or imports a patented invention within the United States during the term of the patent. Direct infringement requires no intent. The act itself creates liability if the patented claims read on the accused product or process. Induced infringement requires knowledge of the patent and specific intent to cause infringement by a third party. Contributory infringement requires knowledge of the patent and the sale of a component with no substantial non-infringing use. A threshold determination in any infringement analysis is claim construction. What do the patent claims mean? The Federal Circuit reviews claim construction de novo on appeal, which contributed to an elevated reversal rate that persisted for many years. The Supreme Court's 2015 decision in Teva Pharmaceuticals USA, Incorporated v. Sandoz, held that subsidiary factual findings underlying claim construction are reviewed for clear error, somewhat limiting the frequency of reversal on claim construction grounds. Patent infringement remedies include injunctive relief, damages, and in cases of willful infringement, enhanced damages up to 3 times the compensatory award under 35 U.S.C. Section 284. The baseline damages measure is a reasonable royalty, determined by a hypothetical negotiation between a willing licensor and a willing licensee at the date infringement began. Courts apply the Georgia-Pacific factors, a 15-factor framework derived from Georgia-Pacific Corporation v. United States Plywood Corporation, 318F Sup. 1116, SDNY 1970, to determine the appropriate royalty rate and base. Lost profits are available where the patentee can demonstrate that, but for the infringement, the patentee would have made the infringer's sales. Applying the 4-factor Pandit test, the Federal Circuit's March 2024 decision in Brumfield v. IBG LLC confirmed that domestic infringement acts can, in limited circumstances, support reasonable royalty damages extending to foreign sales where the domestic act is the proximate cause of those foreign sales. Patent licensing and the economics of patent rights. A patent is a negative right. It does not grant the holder the right to practice the invention, but rather the right to exclude others from doing so. Accordingly, patent licensing is the mechanism by which patent rights are monetized. Exclusive licenses, non-exclusive licenses, and cross-licenses each represent a different commercial arrangement with distinct implications for competitive positioning, tax treatment, and transfer restrictions. Standard essential patents occupy a distinctive position in the licensing framework, where a patent is declared essential to a technical standard administered by a standards development organization. The patent holder typically must offer licenses on fair, reasonable, and non-discriminatory terms. Litigation over the meaning of those terms, particularly over what constitutes a comparable license and what royalty base applies, has consumed significant judicial resources over the past decade. The Federal Circuit's analysis in cases involving technology standards underscores that the commercial significance of a patent portfolio depends not only on claim scope, but on the licensing obligations that attach to it. Legal and regulatory implications. The statutory framework governing United States patents is set forth in Title 35 of the United States Code. The America Invents Act of 2011 made the most significant structural changes to the system since the Patent Act of 1952, converting the country to a first inventor-to-file system, creating the Patent Trial and Appeal Board, and establishing new post-grant proceedings. The USPTO operates under the authority of 35 U.S.C. Section 1 etc. and promulgates examination guidelines through the Manual of Patent Examining Procedure. Subject matter eligibility under 35 U.S.C. Section 101 remains the most active area of legal uncertainty. The USPTO's 2024 guidance update addresses artificial intelligence invention specifically, clarifying that a claimed AI method that improves the functioning of a computer or that achieves a specific technical improvement in a technology is more likely to satisfy the practical application requirement of Step 2A, Prong 2 of the Alice/Mayo framework. Pending legislation in Congress, including various iterations of a Patent Eligibility Restoration Act, has sought to abrogate the judicial exceptions entirely. But as of April 2026, no such legislation has been enacted. The venue provisions of 28 U.S.C. Section 1400B govern where patent infringement suits may be filed. The Supreme Court's 2017 decision in T.C. Heartland LLC v. Kraft Foods Group Brands LLC held that a domestic corporation may be sued for patent infringement only in the judicial district where it is incorporated or where it has committed acts of infringement and has a regular and established place of business. This decision significantly constrained the previous practice of filing the vast majority of patent cases in the Eastern District of Texas, though the Eastern District and the Western District of Texas remain among the most active patent jurisdictions. The export control and national security review provisions of 35 U.S.C. Sections 181 through 188 authorize the Commissioner for Patents to issue a secrecy order on any patent application whose disclosure might be detrimental to national security. An applicant subject to a secrecy order may not file corresponding applications in foreign countries without a foreign filing license from the USPTO. These provisions intersect with the Committee on Foreign Investment in the United States review process when foreign nationals or foreign-controlled entities seek to acquire patent rights in sensitive technology areas.